Since you'll be starting your ethics assignments in the next week or so, I thought this is a good time to review some of the concerns that come up regarding ethical decision making, particularly in times when there seem to be some conflicts or there's really inadequate guidance in the ethical code. The ethical code of the National Association of Social Workers is really pretty thorough and covers most everything, so it's not often that you're going to run into episodes or incidents where you can't find something in the code to help guide your behaviors, yet there will be plenty of times when you find contradictions in the code and need to figure out how to deal with those contradictions. That's what this is going to talk about, and hopefully that's what those exercises you'll be working on during the course of the class will be of some benefit to you. The Code of Ethics developed by the National Association of Social Workers identifies the core values, which I'm sure you're pretty familiar with by this time: service and social justice, dignity and worth of the person, and importance of interpersonal relationships. And I think in that the value of self-determination comes into play, the value of integrity, and also competence, that we are aware of what we're doing and that we have the skills needed to provide the practice that we provide to our clients. We should be aware when our personal values interlock or clash with the values of their profession. Values of the client or the society oftentimes are divergent from our own beliefs and values, and this is something that will be important for us to keep in mind as we work with individuals in the future. Our values are important to us, and it isn't necessary that we compromise our values, but at the same time, we should not expect clients to comply with our own set of values when their own values contradict ours. Self-awareness is really very, very important in this area, as you can imagine. A professional possesses the skill, knowledge, experience, standards, and expertise in whatever areas that he is practicing, and is competent and efficient in that practice. And if a worker is competent and trustworthy, this will benefit society and also improve the reputation of our profession as well. When we lack professionalism in our interventions, of course, clients may be affected by the policies, programs, or practices of the social worker and be hurt by them, and our funding sources may dry up. So we demonstrate different qualities that help to set us apart from others. Some of the characteristics that professional social workers and professionals in general carry is an awareness of environmental and cultural contexts in the lives of our clients. Of course, people are influenced by the past, by the present, and also by future contingencies that cause them to make certain decisions. The circumstances in the client's life influence their health, their longevity, their thoughts, their emotions, what goes on in their body, and how they act. We influence the environment and culture in order to promote health, justice, and well-being for the person. That is part of what we do, and a macro element to our interventions, even when we're primarily working in micro practice. We have to consider family and personal factors because those factors influence the attitudes, beliefs, values, and behaviors of all of us. We should understand our own family values and personal factors as well as our clients, of course. We need to understand the internal structures, the subsystems within our clients' lives, and communication and relationships processes within the family that the individual is involved with. And we should be aware of the theoretical approaches to personality, including type, trait, psychodynamic, behavioral, social cognitive, humanistic theories, and all of those other theories that we're studying this semester. Professional also makes use of the person and environment perspective in the social work field. This is something that has been a standard in our field for a number of years now, and it assists us in assessing and intervening both in primary as well as secondary social systems that the client engages with, and also helps us to become aware and to utilize actual and potential resources in the client's life. Professionals also focus upon developing their knowledge and expertise, and based on the setting, the issues that they engage in at work, the populations they serve, the roles they assume. But they also share a common base of knowledge that's established through the educational programs that are accredited by the Council on Social Work Education. Focusing on self-efficacy for our clients also enables the workers to be collaborative agents of change as well. So here's a pretty little graphic that kind of demonstrates some of the many things that are involved in professionalism, and it's worth taking a moment to take a look at. You see that policy practice is indicated in here. And that doesn't mean that all social workers have to go out and become macro social workers, work in a macro environment for a full-time job. But you're also going to find yourselves working on policy issues even in your micro practices and in your individual work, even if you have a private practice for that matter. So this is a part of what we do. We advocate for improvements in policy on behalf of our clients, no matter where we work. Also, critical thinking and scientific inquiry is mentioned here, and we're going to talk about that in a few slides as well, but I wanted to point that out to you also. So what might it mean when we talk about harming our clients in social work? There are procedures that are designed to protect people that actually have the opposite effect depending upon the circumstances. And harm might include some of the things that are listed here, removing valuable opportunities, incarcerating people against their will for victimless crimes, stigmatizing people by use of negative diagnostic labels, and that's something we'll return to later in the semester when we begin to look at some of the features of the DSM-5. Not fully informing clients so that they can make decisions they would otherwise make, sometimes creating trauma through the actions of our practice itself, and occasionally blaming the client for problems when primary causes come from the environment instead of the individual. Harming in the name of helping might include such activities as using residential facilities for juveniles when excessive force by staff is used in those facilities. Over-medicating clients, and this often happens in skilled nursing facilities in order to help behavior management in understaffed facilities in particular. And any facility for that matter where we have our clients inpatient or outpatient where the staff are overwhelmed and poorly trained. And also unnecessary removal of children from parents when safety really isn't the issue and or viable alternatives exist. And this is something we'll return to also in some class discussions. There is a concept known as the fundamental attribution error that is something that's very useful for us to keep in mind as we make assessments of client situation, the overvaluing of personal internal factors and the undervaluing of environmental and social or external factors. In other words, blaming the victim is a short way of putting this, where we believe that a client's circumstance is really the result of their own choices and decisions and tendencies and characteristics without really examining the social and environmental factors and economic factors that go into the development of those characteristics in the individual. It's always important that we look at the context of the behavior. Situations strongly influence an individual's thoughts, feelings, sensations, behaviors. Don't be a Lucy in this, where Lucy is very critical and overlooks her own faults. Critical thinking is an important thing to keep in mind when we're talking about ethical choices. It is really the integrally related to making ethical decisions, in fact. Critical thinking encourages us to prefer truth to ignorance and prejudice. It causes us to question commonly held assumptions and to seek out other perspectives. It requires us to question the sources of information that we encounter, and also helps us separate information and facts from perspectives and opinions. Part of the issue I think that we have today in the public discourse is the confusion of opinion with information. And a lot of the media provides us with opinion when disguised as information, and that opinion is often used as justification for choices that are made. Critical thinking helps us to avoid the bias that comes with that kind of thinking and to think carefully about our responsibilities in any situation. It may cause us to think about the match between what we say we value and what we do. And then also it emphasizes the importance of honoring our ethical obligations by drawing on practice and policy-related research whenever possible and involving clients as informed participants. Critical thinking means basically not just assuming that what you see or what you're told or what your first impressions are the actual facts, but rather it requires us to look behind what is given to us and find out more information about it before choices are made. A good example of this is the criticisms often leveled at welfare recipients. An example that is made in one textbook that I teach from in my social welfare course is a criticism of a mother who bought a widescreen television for her apartment when she was receiving welfare assistance, feeling that money should have been spent on other things. The outside observers thinking that, when in fact it can be seen as a very appropriate parental decision if it's more likely to keep the children in the home in the after school hours when she may still be at work. Sometimes what seems to be an irresponsible choice is really a very good parental choice in a situation such as that. And that's a little bit about what critical thinking involves in just one really superficial example. The law, of course, comes into our choices as far as ethics are concerned as well. Challenging unethical actions in social work requires that we have not only a knowledge of our values and ethics and the social work code, but also that we know about legal statutes, case law, and the ethical code itself. So none of us are going to be experts on all the different statutes involved in the Alaska statutes or whatever state where you practice, but you are required to understand your obligations and expectations of your role in the statutes. So that part of the statute you need to be very familiar with. And these obligations sometimes are based on common law. Sometimes they come from legislation and regulations that are kind of one step lower than law as far as their importance, and also based on court decisions sometimes. Some laws that we encounter in our work is those related to child abuse and neglect, elder abuse, domestic violence, civil rights, sexual harassment, laws surrounding psychological testing, when it can and cannot be provided and how it can be used, psychotherapy and counseling as well. Laws govern child custody and adoption proceedings, and also marriages and divorce. Any violation of the NASW code may serve as grounds for a malpractice lawsuit, and that's something that you may very well be subject to, so it's important to be very careful about that. NASW Procedures for Professional Review contains guidelines for submitting and adjudicating complaints filed regarding an individual's practice. And the comment that's made here is good practice is the best defense. It's also important to note that if you're supervising others, you are liable not only for your own decisions and actions, but you're also liable for the negligence of those they supervise. So supervising others may seem like kind of a cushy job, but trust me, there are a lot of scary things associated with that, and this is one of them. Here's a sort of a display of the priorities for legal obligations of helping professionals. And I'm not entirely sure that the use of the pyramid here makes sense, but this was just a graphic I found that spelled out legal obligations of our profession. There are times, of course, when confidentiality, which is one of our obligations in our relationships with clients, is limited. And so it's very important early in our relationship that we share when information must be shared so that the client is aware of this. This would include situations involving the danger to self or a danger to others, reports of suspected abuse or neglect of a child or a dependent elder. And so it's very, very important that the client always be informed of this, and this really should be a part of your role induction during your earliest meetings with the client. Tarasoff versus the Regents of the University of California. It was a 1974 case where the parents of a murdered woman sued and won a case where a university psychologist did not inform the victim that a client of his intended to kill her. It's the duty to warn provision in our statutes. We are required to discharge the duty in several ways. We can discharge it in several ways, including notifying law enforcement, warning the intended victim, or taking other reasonable steps to protect the threatened individual. But it's important to know that we must warn the victim when an individual is threatening another person, and those threats are taken seriously in the context of your relationship. This arises from a case somewhere in the late 60s where a student at the University of California was dating a woman that was Tarasoff. And apparently they developed different ideas about their relationship. And she wasn't interested in pursuing a long-term relationship, and he believed that she was. And so when it became obvious that she wasn't interested, he began to stalk her and also began to suffer severe emotional crises as well. And so he went into treatment. At one point told the therapist that he intended to kill her because she wasn't responding to his efforts to reunite with her. So she went away for a summer, and during that period of time, he began to improve in treatment. But he did tell his therapist during that time that he intended to kill her, and the doctor requested that the campus police detain the individual, writing that in his opinion, he suffered from a severe mental illness, and recommended that the defendant be civilly committed as a dangerous person. The police did detain him, but he was released after a short while, and he appeared rational to those who were looking at him. When she returned from being out of state, he began to insinuate himself into her life in ways that I'm not even sure that they were aware of. For instance, for a period of time, he befriended her brother and even moved in with him for a period of time. And a few months later, after she returned from out of state, he did kill her. He stabbed her to death. Parents sued the psychologist and various other employees of the university. And although he was convicted of second-degree murder, nonetheless, this became a prominent case in our field, or any field for that matter. This was a psychologist, but it certainly involves all of us working with individuals. The moral of the story here, I think, one, you do notify law enforcement if an individual is a danger to self or others. But secondly, you also notify, in a case of danger to others, you notify the victim of that. And I think the danger to self, you notify key persons in that individual's life that he may be suicidal or she may be suicidal. But it's important that the victim be informed as well. That's the duty to warn. So you should be familiar with laws in your state regarding issues like this, and also things like reporting HIV infection to public health authorities. All 50 states have statutes that require the reporting of suspected abuse and neglect of children, and also of vulnerable elder adults as well. There are separate agencies in Alaska for that, but we do have an obligation to report each. I was doing some digging around just to see if there's any changes in this, and I wasn't able to find any situation in Alaska where we are required to report domestic violence when it becomes apparent to us. And in fact, HIPAA has some restrictions on us reporting outside of the relationship in the absence of statutes that require reporting. And so this is an area that you should just stay abreast of and remain familiar with. Medical authorities are required to report non-accidental injuries to individuals involving weapons, knives, and those kinds of things, which includes and I think being beat up as well, includes the domestic violence area, but that is not the case for us. What you do with that is going to be very dependent upon your situation, and I'm certainly not saying you brush it off, but you have to listen very closely to what the victim wants in such a situation. There are other areas where litigation or complaints might be filed where there are risks involved, like treatment without consent, being incompetent or making an incorrect diagnosis, not staying current with knowledge in your particular area of practice, not preventing a client's suicide. Again, that's where this duty to warn comes in. That doesn't mean that every client that commits suicide is something you're going to be responsible for. Oftentimes you can't prevent that, and you didn't have the information you needed to see it coming. But when you are aware of it, you have to be very cautious about informing individuals as appropriate. Sexual impropriety, battery also is another area where you may be subject to some complaints, and failure to report when required by law is another area, of course. When you do receive a complaint in your practice, or you receive a complaint about an employee under your supervision perhaps, one of the things you don't want to do is just blow off the complaint and ignore it, because that's one of the things that really prompts more aggressive actions on the part of the complainer. And sometimes when there is a complaint coming from the client, proper handling and empathy in the early stages of that process can eliminate the complaint without it escalating to more formal kinds of levels where there may be a lawsuit, or you are reported to NASW or to the licensing board and those kinds of things. If you're engaging in behaviors that are outright violations of ethics and propriety, those things are going to need to be reported anyway by your supervisor. But in the case of individuals whom you're working with, a lot of times in other areas, if you handle the complaint seriously and with empathy, oftentimes you can resolve that complaint and on an informal level. And here are some examples of doing that, including just making a simple apology for what happened or for its impact. Malpractice is the willful or negligent behavior. There's an or there, not and. Willful or negligent behavior by a professional that either violates the ethical codes or professional standards, proves harmful to the client, might be considered a tort on a legal basis, provides grounds for the individual to seek damages, financial usually, in order to resolve the malpractice complaint. There are different forms of malpractice that are described here: malfeasance, misfeasance, and nonfeasance, which essentially is separated out with intent rather than making a mistake, other than just simply not applying a particular standard or acceptable practice when warranted. Some of the key ethical principles that we're very familiar with in our interactions in our clinical work, especially with clients, are here: self-determination, informed consent, professional boundaries, safeguarding confidentiality. And of course, here again, there are the limits to confidentiality. In when you're subpoenaed, sometimes you don't have any choice. And when you're providing court testimony, sometimes, and the attorney is asking you information that is confidential or privileged, what we often do in those situations is turn to the judge and ask the judge to order us to release that information because it is otherwise confidential. And if there is a court order, then legally speaking, you're protected. And so it's always a good idea to ask for that first. Just because you're on the stand and asked a question about information that might otherwise be confidential does not mean that you automatically share that information if you believe confidentiality statutes apply. Supervision and consultation is another area that sometimes we forget to inform clients that we will be talking with our supervisor as well. So that's another limit to confidentiality. Recording is another area for confidentiality, and here's some guidelines. I think, if I remember correctly, this comes from Hepworth, but there may be some of my own ideas in here as well. And one is record no more than is essential to the services being provided. Record keeping is a skill, and I know you have a writing class, and whether or not that covers that, I don't. In social work, I don't know. But record keeping, first of all, learning to be the terms that I always use is concise but complete, and those two together. Get the essential elements in your records into the record. First of all, if you're working in private practice or you're working for an agency that is going to bill for your services, the insurance company is going to have to see those things in there anyway. But in doing so, and also, of course, the record is indeed what it says. It's a record for you or some other professional perhaps in the future, so that you know what's been covered and how you can kind of chart progress with that record. That's very important, and record keeping is one of those things that for social workers is often the bottom of the list of things to do because we want to interact with people, not do paperwork, or now it's data entry. But record keeping is very, very vital and for many different reasons, including the ability to defend yourself if there was any malpractice lawsuit. However, keep it concise, and this is one of the keys to being able to keep up with your records. If you just simply record everything and you don't cipher out what was important and what wasn't, and this is a part of what you decide as a professional, if you don't cipher that stuff out, you put everything in the record, you have pages and pages and pages of records, which, quite frankly, no one is going to read because it's too involved and too long. Putting in information that's irrelevant, that can also be considered damaging or judgmental about the client, is something that you simply don't want in a record. So omit irrelevant information. Generally speaking, process recordings or verbatim recordings should not be included in case files. That is, in some situations, perhaps like forensic interviews, you have to include verbatim recordings, but in general, it's something that is not recommended. Always update your records. When you do record, make sure that your environment is private and soundproof, and that your records are stored under lock and key. That the information that is transmitted through technology is secure, and that's a whole other area now when people can hack into emails and those kinds of things. Less and less are we using faxes anymore, but we used to ask people to assure us that they would personally stand by the fax to receive the document before we sent it, those kinds of things. Always inform your clients of conditions under which information might be disclosed and how they would be used. One particular difficulty that I ran into a lot of times involved ethics of practice with minors and whether or not minors had the right to the privacy of their records as well. In most cases, what we find out is parents have a right to access the records of their minor children in treatment, whether or not the children want parents to know what they're saying. And that, quite honestly, can intrude upon the trust between you and the adolescent or even the younger child when they're sorting through issues that they're not ready to talk with their parents about. I think ethically, and this is an overstatement, it doesn't apply for every situation, but one of the goals you want to reach is that whatever the child is talking with you about, that child find a way to talk with their parents about that. I mean, that makes good sense. And so if you're talking about information that the child wants you to keep from the parent, perhaps sexual behavior, for instance, or drug behavior, the requirements for drug treatment restrict your ability to share information regarding adolescents' drug use as well. That's something you should be very familiar with. But eventually what you want is the child to be able to share this information with the parents and to be able to discuss it with them. And so you're going to work with the adolescent probably, or the child, to be able to share that stuff. Now, of course, anytime there's a danger to self or others, that's another matter. Anytime there's abuse or neglect allegations, another matter. But in other situations, what I used to tell the minors that I worked with that had those concerns was that they needed to know their parents might have access to records, that if I felt anything that was in the record was something that the parents would use against them in an inappropriate way, that I would go to the mat to protect their privacy and requiring the court to order that record to be released, but that the court did order that, I'd have to do it. Again, here's another situation where while you want to ethically make sure you record everything that should be recorded, don't put in unessential, irrelevant information into records that might be something that harms the client later. That's always an interesting area for discussion, very dynamic, and I had many rather heated discussions with agency heads over that when I was working with teenagers in particular. So there are a number of different models for resolving ethical dilemmas, and the next few slides will cover that, and then we'll be done. And I'm not necessarily going to go through each one because you'll see there's a lot of similarities between them, but I wanted you to see the variety of different ideas, steps we have for resolving dilemmas when ethical codes seem to disagree with each other. And in the Hepworth text that we have used in other classes, and you may be familiar with, he has identifying the problem. Well, actually, they have, because there was a series of authors in this book. He's just the lead author. Identify the problem or dilemma, determine the core principles and competing issues in those problems in that dilemma, consult with colleagues, supervisors, or legal experts when necessary. Talk it over with colleague. And if you're in private practice, hopefully you have established a relationship. And it should be something that is formalized somehow with an agreement of some type or another, with another professional to provide, whether it's mutual supervision or it's a mentor that has more experience that actually provides supervision for you. Don't ever isolate yourself from those kinds of things. So if you have that person, there's the person to consult with. Think about the possible and probable courses of action, decide on your course of action, and develop the strategy for implementing it, and then watch the process and see how it turns out. I put that first just because it seems to be the most obvious model. But there's another model that has catchy little letters, to help you remember. Ethic model, which you can see here is very close to Hepworth model as well, not necessarily in the same order. Again, you see there's a lot of thought and hypotheses about consequences and who would benefit, who would be harmed, and talking it over with colleagues and supervisors. Frederick Reamer is someone who's written book after book about ethics and oftentimes chairs workshops or provides workshops on ethics. When you're looking for CEUs for licensure, for instance, forever, you'll always find Reamer in there, and he's sort of the profession's expert on ethical decision making, and he has a 7-step model for determining and sorting through ethical issues. This focuses specifically on identifying the stakeholders, the groups, organizations, individuals that would be affected, and that's certainly one thing, and that is important, and is identified in other models as well. The decisions ethic model, which doesn't have the benefit of the first letter to help you remember the steps, also is a little more involved and separates out the impact of the value from the impact of self. And again, identifying the stakeholders engaged and looking at other factors engaged, as well as simply the ethical model, but also standards of practice, agency policies, legal considerations, that kind of thing. And the law is another thing that you always need to keep in mind when you're making these decisions, of course. Dolgoff and Associates developed what's called an ethical principles screen that I thought would be useful to you. That when we consult the Code of Ethics, there are times when the code doesn't specifically address the dilemma or provides conflicting guidance. And in these situations, this ethical principles screen gives you a hierarchical arrangement of values and the ranking of those principles. You have to use your judgment, as this is true for any model, any tool that you're given. Remember, you're a professional, and unless you are in an agency where they really could go out and hire people with high school degrees to do your job, you're expected to use your professional wisdom, knowledge, experience, and judgment in making decisions. We don't want to fall back on a situation or a place where we wind up blaming a tool that we've been given to use to help us make a decision, or blaming some sort of guidelines that have been provided for us. If you have your agency usually has a standard operating procedures manual. You have to follow that, and that's a legal matter, by the way. Legally, you are responsible to follow the steps in your SOP, your manual. However, the manual doesn't get into telling you what to do when there's an ethical dilemma. At least I don't know of any that does, or necessarily what to do in every little situation you're engaged in. It's a broader kind of an overview of what your responsibilities are, and you do have to know what's in your manual. And that's something really I didn't mention in any of these slides, and I should have probably. So always be familiar with your manual. And they're usually way too thick to know everything that's in it, but make use of it when you are making decisions whenever possible. Other than that, we don't want to fall back on tools and those kinds of things to make our decisions for us when we also have professional experience and knowledge behind us. The tools are a guide. They're not the decision maker. We are the decision makers. There's a book that this comes from, the Ethical Decisions for Social Work Practice. It's out there if you're interested in it. And this screen has 7 levels, numbered 1 through 7, number 1 being the paramount consideration. There's also a graphic to share this here. A couple different graphics, actually. So they present the ethical principles in order of priority from the, actually, this is wrong. It says from higher order principles to lower order principles. I think it goes from lower to higher. But in any event, you see that the protection of life, of course, is the highest principle, of course, and then you go from there. And there's a pyramid again, I think is probably, I think pyramids can be read in two different ways. But if you look at Maslow's hierarchy, self-actualization is the top of the pyramid. So I suppose the top of the pyramid is the primary thing, right? Another graphic, just if you examine the code for applicable rules, and these rules take precedence over the worker's values, of course, but one or more of a rule applies, you follow the code rule. But if there is no rule that applies, or if the rules provide conflicting guidance, then use the principle screen. That's the suggestion. One other consideration, which is morality in our practice, and there are moral principles for professionals, and morality, really is a very individual thing. When we talk about morality, I don't think we're talking about religious principles here, whether you go to heaven or hell or anything like this. This really is about moral thinking in a broader sense, like the development of moral thinking in children. And so here are some of the principles or qualities in moral thinking for professionals. Beneficence, wanting to do things that are good, non-malfeasance, justice, autonomy, privacy, confidentiality, and fidelity. Being true to your word and being true to your profession and your professional code as well. There are philosophers who argue that the fundamental moral principles really do exist out there, and that they should guide decision-making in all aspects of life, not just our own work as a social worker. And of course, that makes sense when you look at those boxes in the last slide. And certain helping professionals have adopted certain fundamental moral principles as their values. And some of those boxes in the moral principles code, probably all of them really, are a part of the NASW code. It goes without saying that sometimes conforming to one standard or one principle, one ethic in the code may violate another, and that's what makes it a dilemma. So we have to use that critical thinking that we were talking about earlier in order to resolve ethical issues, and use one or more of these models that I just talked about and helping you to decide. That's all I have for this. This is pretty good information, I think, and it's useful in a number of different ways. I hope it isn't too repetitive over things you've heard before. I know some of this is talked about in other classes. but I'm sure every instructor gives you a different twist and different tidbits of information. So I hope that what I have given you is of use to you. And that's it. Thank you very much for listening.